when I join issues, my senior colleague, as we approach court this morning, my colleague Kenneth Paul Kakande, is told from the junction of the main road. The road is closed, access is restricted. The full introduction as to identification and purpose for which we are coming to court. In our interaction, it was noted that even the public which we used at least for access from the main road on the sides were precluded. Waiting from there. Your record on the last appearances, when we required the relatives of one of the accused persons has to access to them. On the roadside. So these actions of stopping the relatives, friends, public is making our work live alone. Making lawyers explain themselves whenever they appear. This is unnecessary, it's uncalled for, it's unreasonable. We seek the protection of this court. We run us to the third application. We were required by this honorable court to produce a birth certificate of Muwanga Wilson, as the remaining requirement proof that is actually 17. The court, being an expert of experts, made a decision that he deserved to be in command home. The order was made by this honorable court. Remand order was made to Naguru remand home, but the remand home refused to abide by that order. The accused person was left hanging between the remand home and the prison, was left in space. And ever since, Muwanga Wilson has been held at the Naguru Remand Police Post. Ever since, been detained at police in Nakuru. Total contempt of the orders of this court and disregard the status of the accused person. Your Honor, that complicated access to the child by the parents and difficulty to the lawyers. It also became complicated to produce him before this honorable court this morning. For the remand, police did not have facilities order so to do. To explain to police, and they escorted him on border in motorbike all the way from Nakuru to this court. All this under the hands of the state. Wish that this be noted at the background of the application that we are going to make. And report to this honorable court that we managed to get the birth certificate, Mira, top of which try to admit as proof that he was born on the fourth day, that Linda Wilson was born on the 4th day of November 2008. Therefore, born at Wakiso, Nansana, sub-county, Maguere South, to one Chiria Richard and Nantes Salima. Details, these are the details of the. So that court finds this sufficient evidence to prove. How many? 17. 17 years. And it's upon that decision that we may have to make the further prayers. We almost obeyed.
Agenda is the 19, number 4. F for worship.
So what do you say is the
Worship in respect of what on the notification protocol.
on the issues that council have raised? They have raised several things.
Worship. Starting with the submission of transfer areas to population. Worship has told court that we have failed to tell them how far we have gone with the investigation. However, your worship, I was very clear on this. Your worship, we are finalizing with the committee papers, your worship. And that shows your worship how far we have gone in this matter. Your worship, it's not true that we are laying this matter as council alleges. And we have used actually reasonable time in handling this matter. Your worship, council is trying to direct on how investigation should be done, which I think is not proper. The people conducting the investigations are professional and they know what they are doing, your worship. And as prosecution, your worship, we undertake to make disclosure at the appropriate time. And I think council knows all the procedure. All the necessary disclosure will be available to your worship. Your worship, in respect of blocking people to access court, your worship. Your worship, as prosecution, we are not a party to this. We are not party to blocking of people. We were not aware that they were actually blocked from accessing court. We don't know the people behind it and the reason as to why it is being done, your worship. It cannot be put on prosecution. Maybe the relevant or the concerned people should be put to task as to why they are doing so.
I wish you had consulted the DPP, I mean the DPC.
Your worship,
When the minister raised the matter, why did you make an assignment to the DPC?
Your worship, I don't know who is behind it. So I couldn't approach anyone without having notice of who is behind it, your worship.
And a matter of that nature be done in the district without the knowledge of the DPC.
Your worship, it has just come to my attention at this time that people were blocked.
And that's why I am saying, when Mr. raised it, you should have been able to, where is the DPC him. You are not party to the blocking of the public.
No, your worship. And actually, I wasn't aware that they were blocked.
So you think the council should address this matter?
I think, Your Worship, we need to first find out who is behind it and why it's being done. Because I have no information about it, Your Worship. Your Worship, in respect of council, Ms. Your Worship has informed both that they have been able to produce the birth certificate from Linda Wilson, Your Worship. However, Your Worship, the document which has been availed to me is a birth notification record and not a birth certificate. Your Worship, you are all parents, and we know that this document is issued when you go to apply for a birth certificate. And it is issued on the day you apply, you go for the application. Your Worship, this document was applied for on 13th of April 2026. It was applied for on 13th April 2026. When we worship, this matter is already in court. So we cannot take it that the whatever is reflected here is the truth, Your Worship. Your Worship, it would have been different if it was the immunization card or baptism card which had been presented. So I pray that this document not be solely relied on, and in that regard, Your Worship, will pray for a fresh, maybe re-examination to be done. A fresh re-examination be done, Your Worship, to ascertain his correct age, Your Worship. Your Worship, Council has also said that Nagurima refused to accept Moinda Wilson. Maybe the information I have got about that is that Nagu refused to admit him because there was no PF24 to back his age, and the only document which accompanied him was the document from where he was examined, and it showed that he was an adult, and that was the basis for refusing him. And that's why, Your Worship, I will pray for a fresh re-examination.
The issues at the meeting because of what?
There was no PF24 showing that he was below 18 years. Your Worship, the only document which accompanied him was that of the examination which was done from Action Bank, and it showed that he was an adult. So we couldn't admit him on that basis. The premises, Your Worship, I will seek an adjournment.
No, you didn't respond to some matter that not by the
For example, Your Worship,
you talked about the date, yes, the home opportunity number 1.
Your Worship, all those are involved in the investigation, and we undertake to do disclosure to that effect at the appropriate time, Your Worship. Your Worship, that is part of the investigation.
The complaint is Mr. Power that you not had accused number 1 make a statement.
Your Worship, we have a statement for the accused person.
He made a statement.
Yes, Your Worship. And Your Worship, if they think that we are doing it in a wrong way, Your Worship, they can reserve that for their defense, Your Worship, to be clear, because it will be for their benefit.
What they are saying is essentially that if you investigate the matter locally, maybe you will not charge. That's what they are saying.
Then, Your Worship,
They are
that
complaining
means that
about lopsided investigations, and they are saying if you did that investigation, maybe you will not be charging. They are doing discussion.
Your Worship, I think the duty of charging or not charging is not for the defense counsel, Your Worship. And no one can be charged, Your Worship, without evidence, because the file is perused before any charge is being prepared. By the time any charge is prepared, there is evidence to that.
Well, let me what it is.
If it may please you, Your Honor, seeking indulgence that we first put the issue of birth certificate out of the way, then the colleague will conclude. Yes, Your Honor, our short rejoinder is that the state submitted that she's about to submit. She is ignorant of the process. She doesn't know the process. On the 10th date of April 2026, the mother notified as submitted by her official document. As proof of birth was issued on the 13th. So the notification is true. One of the processes was done on 10th. That review official document was produced on 13th. Public report. Yeah. And we pray that the submission be disregarded. And we reiterate birth certificate or even notification by mirror is official communication to this honorable court as far as the date of birth is concerned. This court will not reopen its decision. It's upon doubt that was cast on the report of the expert. The current alternative was ordered and directed by this honorable court. I believe this will satisfy this honorable court as to age.
Yeah, Mr. Minister, you don't think the context of the birth certificate will be different from the context of the birth certificate? It cannot come when it is different from what is here.
Your Honor, if you check the official record, you will get that's the record of Mira. The record, official record of Mira as to age. That will not change. It cannot change.
Could you figure out these two issues? It's not satisfactory. Let me expound it, Your Worship. Just in the interest of justice. The purpose of this trial process, the spirit, the rationale, is for this honorable court to superintend over the matters regarding investigations. So that by the time committee is done, everything is exhausted. All issues regarding investigations are exhausted. Your Worship, if you looked at the provisions of section 168 of the MCA, once committee is done, the hands of this honorable court are tied as far as issues with the investigations are concerned. And the submission of the state is that if there are loopholes, and they have done it in a sloppy manner, then we take a benefit of the same. That is not the spirit of dispensation of justice. We are officers of God. We are not here to take benefit or take advantage of the sloppiness of the state. We are here to facilitate a process of arriving at the truth and ensuring that justice is done. That is our role as officers of the court. So it's the reason we are saying, Your Worship, as you are supervising the processes of investigations, that at least the statement is recorded from our client. The accused. It's not there. That's not true. Your Worship, we have said on several occasions, we have put on record, midway recording the statement on the issue of the murder of the people at Mrs. Home cropped up and insisted that that line should be investigated. The process aborted. So there's no statement. So it's a matter of concern, not only to the accused person and the co-accused, not only the people of Ogogoye or Tanga, not only Ugandans, but humanity in general, that we get to the bottom of the matter. Who pulled the trigger and killed the 7 people at the home of Honorable Muwanga? I think it's a matter of great public concern which must be investigated. And we are ready to help with that investigation. It's not a question of preparing the committee of papers hurriedly. Of course, we want to expedite the process. We need to have that aspect investigated. Lastly, on that particular issue, the contention that the state has used reasonable time. I think this is a matter which also needs to be addressed by this one of the court. What is reasonable under the circumstances, Your Worship? The incident we are talking about in this particular matter is alleged to have happened on 14th of January. The charge sheet was prepared on 30th of January. Today is 14th April. That is it a reasonable time? And no progress has been made. That reasonable time? I must applaud the DPP and the state for that matter in the case of the Gaba daycare murder. The accused person, Your Worship, if you have taken judicial notice of the state, the accused person is presented that today, the following day was committed. Today, the matter was put for mention, the following day, committed. And the trial has already started. In comparative terms, when you look at the proceedings before you, ever since we started appearing, what has happened? Nothing. Nothing. We come, after it's that journey, even these 2 weeks they are asking, it will be the same story. I'm sorry, with all due respect to my sister. When we come back here, we say, there are a few things we need to fix. We are yet to finalize. Give us more time. As the accused person is continuing to rot in Chicago. And it was up. And of course, the children remained home in Norfolk. That is a violation of the letter and the spirit of Article 28 of the Constitution, Your Worship, which should not be condoned by this matter. Regarding the third issue, Your Worship, about the fact that the second issue of blocking members of the public from accessing to premises here. The state cannot run away from its obligation. No. It cannot be another question. The representative of all the agencies before court, the agencies of state, is my dear sister here. She's an embodiment of the police, embodiment of UPPF, embodiment of SFC, all these security agencies that handle matters to do with criminal investigations and prosecution and handling of suspects and what, not even prisons authorities. This is the state. And the face of the state is my sister here now. So you watch it. This is a very serious matter. The Article 28 was not made in vain. Why the hearing should be made public? It was not made in vain. It is derived from the principle enshrined in Article 28, or rather Article 126. If I may read Article 126, my Lord, for emphasis sake, judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with the law and with the values, norms, and aspirations of the people. So, Article 126 emphasizes that point that whatever is done by this honorable court is done in the name of the people and for the people. And therefore the people should be allowed to witness whatever is happening. Actually, it is the spirit behind this new phenomenon of mobile court, as it was elucidated by the Chief Justice. So, Your Worship, the environment we have here, the public is not allowed to witness what is happening. It's not conducive for administration of justice. And my dear sister here cannot just simply talk about it in a cursory manner. Your Worship, if I may disclose to you, even some of us here, we feel in such a way when we are here, we feel you're not comfortable to free exercise your, if you may look at what is happening in the window there. I'm serious. Look at that gun which is placed in it. It has clothing. It's the first of its kind. I've never seen it in my life. That is dressed like a human being. So it's a matter it is dressed like a human being.
When it is dressed like that, it means it's not going to be ready. It's not going to be applied immediately.
So, Your Worship, this is what is making us feel very uncomfortable in this kind of environment. And I'm glad, Your Worship, as I conclude, my sister has not objected to our prayer to have a mobile court, the home of Muwanga Kivumbi. She has not objected to that, to the prayer we made. Like the proceedings in Ghana. Very interesting. We are all following what is happening there. The public is seated in the tent there. They are all witnessing what is going on. I wish it would happen in this case that we are seated at the home of Muwanga, at Bugoye, and then we have the proceedings conducted from there. So that the public is witnessing what is happening as their power is being exercised by this honorable court. So we do so pray, Your Worship.
Your indulgence, children, students, we emphasize the necessity of a clear path also on the ground. And finding that we have children who were arraigned. Many of them are school-going children, Your Honor. Your Honor, actually, Wilson Muwanga has just passed his O-level with a high recognition by the school, pending admission. High recognition. We got 6 B's, 3 C's, aggregate 18. He's the youngest. This group pending your findings. So it's such compelling reasons why we believe there should be a clear path. We have students here school going. So that we know whether even by the time probably they may decide to drop charges against some, as any reasonable person will do in the state. Probably they would have lost the year. So that is why we deliver on that issue. Your Honor, again I rise on Muwanga Paul. Muwanga Paul was found to be at least below 18. The law commands that this honorable court should guide what is in the best interest of the child, the best interest principle should guide the directions of this honorable court.
What you want us to do, the respect of what you have announced in
Your Honor,
number 19, I want. What do you want us to do?
no, Mawanda, I have specific prayers, but I want you to be orderly after hearing on your findings on the page of the report, so that I will proceed jointly on them. The necessary applications that we shall make. But we're not all over the place.
You want me to make a finding about the age?
No, on whether this is sufficient, whether that.
And I wouldn't have a problem with it. Because my view is that the nature that birth certificate were to be produced, it wouldn't differ, the content wouldn't differ from what is here already.
At this moment, we should make my application. Your Honor, first Muwanga Wilson. Again, I wish to inform this court that apart from him being at police as we speak, even the cost of him being brought here are borne by the parents on border. It's really for the background against which I wish now to make an application which can be clear on where he should be. That should be with his parents. You know, I premise this application in section 135.
Your
Application.
your prayer is the what? Your application.
I'm making an application for bail so that it is determined where he ought to be. That is with his parents, not at police. The application for bail is premised on section 135. Of the Children Act, Cap 62. And paragraph 17 of the Judicature Bail Guidelines for Courts of Judicature.
Paragraph what?
Paragraph 17. Brackets, bail guidelines for courts of judicature, bracket, close brackets. Then bracket practice, bracket directions for 2022. You know that these provisions mandate this honorable court, for which Linda Wilson has appeared. Uphold, it enjoins this court to uphold his right of applying for bail and being admitted to bail. On our understanding of this law, any court includes the magistrate's court, though a capital offense, it can hear and determine the bail application for this child. Brevity guidance. Section 135 states that where a child appears before the court charged with an offense, the magistrate or person presiding over the court shall inquire into the case, and unless there is a serious danger to the child, release the child from bail, on court bond, or the child's own recognizance, B, with sureties, preferably the parent or guardian of the child, who shall be bound with a non-cash court bond. Your Honor, before you, we have the mother of Melinda Wilson. Nanteza Salima. And his paternal auntie, Nasazi Rebecca. The mother, Nanteza Salima, is 38 years old. The mother to the 17-year-old is 38 years old. A resident of Wamala, Nansana. She operates a saloon at the home premises. She has national identity identification card. All these details.
ID card is number 1.
ID is number. Your Honor, it is number CF 87026107 U2QH. I have an original copy. Report. It clearly states the residence. We submit that she qualifies under 135B. The second parent, Nasazi Rebecca, is 43 years old. This one has a copy of her ID. F 830 801 801 00 LYWA. She has a copy of the cell. Now this one lost the original, that is a copy. She has letters. Yes, and actually voters identification slip. She submitted all this. Now we pray that you find that is qualified under paragraph B. He's seeking your compassion. The child. Put him in the right place. And not police detention where he is. Secondly, I wish to note, Your Honor, that quote and note that he is a student in St. Mark's College, Muwanga, the school going child, S4. We have just completed S4. The results of public record are that is qualified. That will get 18 to join HSC. Gonna all this with inform the judicial discretion. In that meeting, you and I, they in the hands of his parents. So I've explained to them what this means, both parents. That they should ensure that whenever it is required, he attends this court. Same to understand the same, and your inquiry as the law guides Your Honor. It's within your family. We submit that the child cannot be any secure in any hands but those of parents. The issue of security, we submit that there will be secure hands within their parents' lands at Wamala in Nasta. Any other issues have to be guided by this honorable court. If it's so, this is the most obliged.
If the respect
Of Wilson. And since they are here, this court is probably to qualify of them.
and proceed.
Obliged. Your Honor, in respect to Muwanga Hall, first, let's be on record, Muwanga Hall has complained about the feeding in Nakurima for him is there. Actually, in his own words, it is even worse than the prison where he came from. He has complained about conditions in Nakuru, one home. He has added more further information to this honorable court for purposes of reapplication for bail. The grounds, the reasons for denial were that the situation is still volatile in this locality. Your Honor, actually, we did not have the information at the time. We submit that we are under court. He actually is a resident of Malere Bomba. Bomba is outside this constituency. It's outside this district. That's the problem we have with the age was wrong, as I'll submit. He still lives with his parents, and actually his mother, Nampija Susan. Nampija Susan's national ID, the record is very clear that she is from Gomba. The record will be very clear still that this juvenile was arrested even before the election. If it's about the election date, was arrested on the 14th date of January. While in town. What in Bulo? Not at the explosive scene of the 15th or 16th. As I said, the national ID is very clear that the mother with whom he stays is from Gomba. The mothers produced her national ID. Vide NINCF 87 0 9 110 39 V 1 C. She is before this court. She's 39 years old. She operates a restaurant. Told me where do you occasionally? Huh? In Malede, Gom. To assure you, to convince you, if admitted, that would wish away the constitutional protection of a child, and admitting him to bed. We are most obliged.
No, that is the one. Is it possible to come with the LC
You wanna
vote for their character?
with the child, someone just prefers to but be a mother. That's what I'm saying there. The issue is about mother. If someone qualifies to be a parent, someone has to be placed in hands of the parent. That is the qualification that I'm saying. I'm sorry, I'm not more very carefully. The parent, that is what they occupy. And that is why the court is enjoined to inquire. It's about safety. If the hands where the condition is being. It's not ours to overindulge. If you looked at these provisions and the provisions of bail, you would find that they differ.
Now, how would we know that she's the mother of this boy?
Yes, that is the inquiry. It's called. I cannot submit from the board.
Because I never see that I will do that today.
That's why court sets conditions. We don't oblige to the condition upon the investigation of what is required. We don't oblige the condition of grant in whatever we can produce.
Prosecution. Children are applying for bail,
Actually, it's true under section 155 of the Children's Act, they have a right to apply for bail. And with my worship, I do object to the application. Worship, in respect of F4, that is F4, that is Moyinda Wilson. Worship, he said he's still in contention, worship. Lordship, I still contend that a birth notification record is not a birth certificate. And it cannot be solely relied on to prove his age, Your Worship. Your Worship, secondly, they are saying that Muwanga Wilson is a student who finished his senior form. I don't dispute that. However, being the fact that he sat for senior form, I think a pass slip would be more relevant because it usually indicates the age of the what? Of the person sitting exams, Your Worship. I'm not sure whether they are out now, but it would serve more purpose, Your Worship, because it usually indicates the age of the candidate, which, however, it hasn't been provided. Your Worship, in respect of the surety is presented. They are all residents outside the jurisdiction of this honorable court. Your Worship, they haven't provided LC letters which would guide court to establish whether they are actually the biological parents of these accused persons. Your Worship, in case these accused persons are released and they don't appear in court, in case these accused persons are released and they don't appear in court, it will be very hard for us to trace for them, since we don't know the LCs where they reside, Your Worship, and since we haven't known whether they are actually the biological parents of the accused persons. The thing says, Your Worship, I pray that the law be denied and matter be returned. So pray.
Your Honor, briefly, she said she's a mother. Yes, that is very key in this. We are producing parents, and she's on record having stated so. And she's serving the public. The ratio here, we don't think anyone should give a child. I don't believe anyone would prefer to keep a child in custody, save for serious grounds. The requirement of the law is she has to prove that there is serious danger, because hers is not just to convict a child. It includes protection of the right as the state of the child. She represents the state, which has a cardinal duty. And I don't believe those are high instructions from the state. they have personal submissions because the state is enjoined to protect the child. She's being unkind. Your Honor, as to proof of birth, this court has already made its finding, but I'll add, proof of birth is either by birth certificate, baptism card, immunization card, national ID, or passport. But the best evidence, official record, is the birth certificate. But I will rest that case, I will not reopen. You are guided by the Honorable Court. Because even a statutory declaration, that's why she's here before you. Her declaration to the public and to you, a statutory declaration in the investigation inquiry before you would suffice. Unless rebutted. She has not submitted on that there is fear or danger to the child. So that's the requirement. Your Honor, as to parentage, an LC letter is not proof of birth. It does not fit. It is a hangover of the bail application for the adults, which is ordinarily objected to. This is mainly a preserve of the court to save the rights of a child. Unless she wants this court to order a DNA test, which would be out of, it would be high-handed. Your Honor, once this Honorable Court is satisfied in the circumstances of the case, the child may be safe in the hands of the person presented as parent, may admit the person on bail with, without an LC letter. It goes without saying, being a child, she has no national ID. He has no national ID. Neither does he have a passport. We will reiterate our prayers, seeking the benevolence of this Honorable Court to the child. Admit them, both applicants on bail. We are most grateful.
for the matter raised by Mr. Muwanga, let me take time to consider and pronounce myself on the 28th. As for the day application, let me come back.
Alright, return data, Charlie.
Tanzania.
Wow. Right, wetembera weri wano kokoti mulungi atulaba ku JP Muwanga, mulungi atulaba ku Uganda Media One, mbeera bwetyo weri wano kokoti e Butambala akaseera kano omulungi atulaba era obwedde atugoberera songa guno gukyagenda mu maaso byonna nga bwe mubiwulidde ate tumuvaako tugenda kubanga tubawa so babe nga ate babanyonnyola biki ate bagenda kubanga bazaako ki mu guno omusango. Mbeera bwetyo bweri gwe mulungi atulaba wano ku Uganda Media One, naawe atulaba ku JP Muwanga, naawe atulaba ku Prosecution TV. Bwetyo embeera bwekyali okulaba nga tubaweereza buli kimu. Tuli wano ku kooti e Butambala, omulungi atulaba akaseera kano gwe ali ku JP Muwanga, tukwebaza bwebaza. Naawe ali ku Uganda Media One, naawe ali ku Prosecution TV. Bwetyo embeera bwekyali okulaba nga buli kimu tukibaweereza wano mu kooti e Butambala. Tukyali ku kooti mulungi atulaba akaseera kano okubanga ate ekimu kikyatambula mulungi atulaba akaseera kano.
Shafiq.
Alright, mulungi atulaba akaseera kano wetembera bukyali kooti eyimiriddemu obuyimirizi katono nnyo era tugenda kubanga buli kimu tukibawa. Omulungi atulaba kooti eyimiriddemu ate tugenda kubanga era tubaweereza buli kimu ekifaanano. Kooti eyimiriddemu okwo era tugenda kubanga tubawa mugendereko mugoberere mugenda kuba mufuna final results.
kananga obulamu obulina fena nnyo nze nali wano mbasomyeko obukumanya mugenda wakasina transport anzaayo eka basiri olera muwanga kivumbi akaana kusente naye kamberegereze yakudda kooti ngezeemwe tujakudda kooti ezeemu.
Alright, omulungi ndaba kamunzikirize nsooke nveeko okwo katono nnyo. Ngenda kukomawo okwo nga kooti ezzeemu. Ngenda kukomawo nga kooti ezzeemu. Omulungi ndaba ku JP Muwonge, ndaba ku Uganda Media wano, ndaba ku Lukirio TV. Wendi okuba nga mbaweereza buli kimu naye munzikirize nsooke nveeko ngenda kudda nga kooti ezzeemu.